The legal struggle between 23XI Racing, Front Row Motorsports, and NASCAR has intensified, and this time it may have catastrophic ramifications for 23XI. This difficulty stems from their charters, which allow clubs to compete in all Cup Series tournaments and guarantee a certain amount of prize money. Without a charter, teams must qualify for races while earning less money. The current issue is whether NASCAR may restrict teams from suing after signing a charter agreement. In late 2024, during the off-season before the 2025 NASCAR Cup Series began, 23XI Racing and Front Row Motorsports won a major court dispute. Kenneth Bell, a judge, determined that the two clubs could continue to operate under their charters until 2025. This meant they could each use 3 charters, which provided them with substantial financial support and guaranteed entrance to all races. They were also able to complete the acquisition of further charters from Stewart-Haas Racing, another racing team. So, for the 2025 season, they employed a total of 6 charters, 3 for 23XI and 3 for Front Row. The problem started with a provision added to NASCAR's charter agreement in 2025. This provision was also known as a release clause, or the "you can't sue us" clause. It said that if a team signed the agreement, they waived their right to sue NASCAR. Judge Bell stated that this was unfair. He claimed that this restriction violated antitrust laws, which are intended to prevent companies from acting like monopolies or unfairly controlling everything. As a result, he granted the teams a preliminary injunction. That's a legal ruling that allows the teams to continue utilizing their charters while the wider legal battle plays out. In June 2025, 16 races into the NASCAR season, the legal struggle is heating up once more. NASCAR just convened a second hearing to challenge the earlier decision. This implies NASCAR has asked another panel of judges to review the verdict and perhaps change it. This hearing did not cover the complete antitrust complaint. It was merely about the preliminary injunction and the constitutionality of the "you can't sue us" provision. During the hearing, NASCAR's lawyer Chris Yates argued that phrases such as the "you can't sue us" provision had previously been in past agreements and were not considered unlawful. He insisted that NASCAR was doing nothing wrong by including it. On the other hand, the racing team's attorney, Jeffrey Kessler, claimed that revoking the charters would be tremendously detrimental to the teams. He added that charters are directly tied to driver and sponsor contracts. If the teams lose their charters, they risk losing drivers, sponsors, and a large sum of money. The 3 judges in this case probed the racing team's lawyers with a series of challenging questions. They noticed that the teams appeared to be looking for both items at once. They refused to sign the new agreement because they disagreed with it, and they sued NASCAR. However, they also wanted to continue using the charters. The judges commented that this was like having your cake and eating it too. They believe the teams should have either signed the charter and relinquished their right to litigate, or refused to sign and accepted the risk of not having a charter. The judges have not made a final decision yet. This could occur over the next few days or weeks. However, many people who listened to the 45-minute discussion feel the judges will side with NASCAR. They did indicate that the teams could have a good antitrust case overall, but that was not the emphasis of this session. They only assessed whether the release clause was lawful. If the judges overturn the preliminary injunction, 23XI and Front Row Motorsports will face severe consequences. They could lose the 6 charters they are now using. They may return to Stewart-Haas Racing or NASCAR. Without charters, both teams would compete as open teams. This means they'd get less money and have to qualify for each event instead of being guaranteed a spot. NASCAR permits only 40 cars to race every weekend. If more than 40 cars show up, the open teams will compete for a limited number of spots. This raises the risk. Furthermore, chartered teams reap greater benefits from prize money and sponsorship agreements. Losing their charters would mean a considerable loss of income for the teams. There's also the question of what happens to the drivers. Tyler Reddick is an important figure. According to court documents, his contract is predicated on the team having a charter. If the charter is no longer in effect, the team may have breached its contract. Tyler may not quit in the middle of the season, but his absence might have serious consequences for the 2026 season. Sponsors prefer to work with chartered teams, which may affect their contracts as well. This legal dispute has been festering for a time. Teams have claimed that NASCAR wields too much authority and that its charter structure is unfair. NASCAR believes that the technique ensures continuity for teams while also protecting the value of charters. A charter currently costs millions of dollars. For example, some have sold for more than $25 million. That's why teams want to protect and utilize them. When the court initially granted the injunction, it looked that the power dynamics in the case had shifted. Previously, NASCAR held the bulk of control. However, after the injunction was in place, the teams seemed to gain traction, but the legal case was far from over. NASCAR quickly appealed the injunction, hoping to get it overturned. A panel of 3 judges heard arguments regarding whether the injunction should be upheld or withdrawn. If it is overturned, the 2311 and Front Row could face serious hurdles for the remainder of the season. The court hearing on this appeal was held in Richmond. The judges made it clear that they wanted both sides, NASCAR and the teams, to attend mediation and try to address their differences. They did not make a final judgment that day, but many who witnessed the session reported that the judges appeared to be leaning toward canceling the order. If this occurs, the pressure will shift back onto the teams. Jeffrey Kessler, the lawyers representing 2311 and Front Row, also warned the judges that revoking the injunction in the middle of the season could cause problems in the NASCAR Cup Series. He reminded them that the injunction is only effective until November 2024, and the entire trial is planned for December. That's when a long-term decision will be made. He also stated that this is a temporary decree, and canceling it prematurely could have catastrophic effects. A large element of the court's decision could be based on a clause in NASCAR rules. This clause specifies that the teams will not sue NASCAR. This release provision may have a substantial impact on whether the injunction is upheld or not. If courts find the teams waived their right to suit, they may rule in favor of NASCAR. For the time being, teams like 2311 and Front Row are clinging on and racing. However, their future is not certain. If they lose their charters, they may be forced to downsize or exit the sport. What happens next might have long-term consequences for NASCAR's power structure. If the preliminary injunction is overturned, and 2311 Racing and Front Row Motorsports lose access to their charters, the consequences will extend well beyond these 2 teams. It will send a message to every group on the grid. Legal action is expensive, and questioning NASCAR's authority, even in court, might not be worth the risk. However, if the injunction is upheld and the case goes to full trial in December, it will pave the way for a broader discussion about the balance of power in modern motorsport. Teams have long contended that NASCAR wields excessive power, using its position as the sport's gatekeeper to impose restrictive conditions and limit team autonomy. This court battle is about more than just 6 charters. It is about setting the boundaries between sanctioning bodies and competitors. Meanwhile, 2311 and Front Row must deal with uncertainty, fielding competitive entries while negotiating a legal quagmire. Their sponsors, drivers, and crew are paying close attention. The same goes for the rest of the pasture. Tyler Reddick's contract, sponsor negotiations, and 2026 preparations are all in the balance. If the court sides with NASCAR, clubs will have to reconsider how they negotiate contracts, structure ownership, and communicate with league leadership in the future. In a sport that values speed, control, and precision, this legal stalemate has created a rare type of chaos, one that no race strategy can resolve. With a potential ruling just days away, all eyes are now focused on the courtroom, where the fate of many teams, and possibly the entire charter system, will be decided. Whatever happens, one thing is certain: the outcome of this case will shape NASCAR's future. What are your thoughts?